Now, as we established earlier, processes leading to the passage of the bill started somewhere 2021.
Yes.
Subsequently, a petition was submitted to the Speaker of Parliament by some 7 members on a private members bill.
Yes.
And then there was, it went through the process. So if you can just remind viewers
So
the events that led.
started in 2021, as you mentioned. It was started by some private members in Parliament. So these members included the majority and the minority. You had people like Sam George, you had people like the MP for Adaklu, all of them coming in, including the Deputy Minister of Education at the time, who also joined this particular signature, puts in a signature to challenge, to send this bill before the Speaker. The Speaker before that had already had concerns about the activities of LGBTQ activists, and he had met with a number of people where he raised concerns and actually indicated that they were going to look at a law to ban or to restrict or stop such actions, activities by such people. Not long after, this private members bill was sent to Parliament. When it was sent to Parliament, it was accepted by the Speaker. It went through the processes. People were invited to bring in their views. You had people, human rights concerns, which were brought before the committee dealing with this particular bill. You had institutions like SHRAJ going to having presentations before the committee. You had other interested parties who wanted to contribute to the formation of this bill. The Attorney General later came in. He also wrote an opinion, and in his opinion, he indicated that he felt or believed that this particular bill should come from the government. It should be sponsored by the government, based on certain concerns he had, that there were some financial implications at the time, per the bill when they looked at it or when it was under consideration at the time. And hence, once there were financial considerations, it should be sponsored by the government, not a private member's bill, because a private member cannot determine what financial obligations the government can have or take. So the Attorney General raised concerns about this thing. This bill went through the various processes. It was amended, had a number of times. There were even concerns about the number of years and punishment which should be meted out to people who are found guilty to have broken.
Even the name.
Yes, actually, even the name.
Because I think it started as the promotion of human rights, human sexual rights, and Ghanaian Family Values Bill.
Exactly.
Yeah.
Eventually ended up at the Human Sexual Rights and Family Values Bill 2024. So, it went through all these till it got to the day of passage. Don't forget that this particular bill started in 2021, as you mentioned. There were even concerns about the delay of the bill. Even allegations were made against the chairman of the Constitutional and Legal Committee at the time, of Parliament at the time, the chairman of the time, that he was deliberately delaying the passage of the bill. So the bill had gone through different phases till 2024, February, where it was passed. Once it was passed, then there was this challenge. The challenge in court sent by Dr. Amanda Odwe and Dr. Richard Delaskai, a private legal practitioner. Their concerns were simple. For Richard Delaskai, his concern on this matter was that at the time of passage, Parliament did not have the requisite numbers to pass that particular bill. So they didn't have the quorum to pass that particular bill. And hence, he felt that that was against the Constitution, because the Constitution had given a quorum for passage, a quorum for sitting. Don't forget that recently, even with the issue of the majority-minority, who was majority-minority, the Speaker actually indicated and raised such concerns of having quorum to sit and quorum to take decisions. Richard Sky went to court indicating that the Parliament at the time of sitting to pass the bill did not have the quorum to pass or take decisions. Hence, he felt that the passage was unconstitutional. There was also the concern about the financial implications the bill had on the state, and the fact that per the Constitution, an individual or a private person cannot bring a financial burden onto the state. So that particular bill should be one promoted by the government. So these were the major concerns. Outside that, there were issues of human rights concerns.
And it's on the financial curve on which they sought the injunction to restrain Parliament.
Exactly. So they actually even argued on Article 108 of the Constitution, where they are saying that the Parliament breached that particular article by trying to bring a financial burden on Parliament, on the government, which is not coming from government.
Right.
So these were some of the
And
concerns.
I think this was the earlier position of the Attorney General as
Exactly. This was the earlier position of Attorney General.
Because
a position which
the
was
bill
also held.
impacts or places a financial constraint on the government.
Exactly. A position which was held by Dr. Mandawe. She is an academic and a human rights activist. She had concerns with this. So generally, this is what was sent to court. But at the time it was sent to court, Parliament was about to transmit that bill to the presidency for assent or otherwise. But what happened was that there was an injunction application as part of the suit to stop the transmission of the bill from Parliament to the presidency. This raised a lot of concerns amongst members or proponents of this bill, who felt like at the time it was a deliberate move to stop the president from even assenting the bill, looking at the pressure the public was putting on the presidency and government to sign. This bill seemed to have been popular amongst the general public. So there was a belief that once it goes to the president would be forced to sign it. So there was the injunction application. The court had to now make a decision on that injunction application. What the court did was that it put on hold that injunction application and said that, look, we'll make a decision at the end of the hearing. So that injunction application was a bit moot at the time, because now you couldn't send the bill, and the bill too couldn't have been signed. But today what happened? After a back and forth on this matter, the speaker in Parliament having representations, arguments made by both sides, the Supreme Court finally came to the decision that this particular application or this particular suit did not hold water. Was at the time it was brought, there was no enactment.
Right.
There is no law.
Right.
Which the Supreme Court can stand on and overturn. So the Supreme Court dismissed the two suits.
But what my question here is it this reasoning, this thin reasoning, because it says that it will give proper reasoning to its decision by Friday. Is it applicable to both suits? Because there's one on constitutionality and there's one on human rights.
Exactly. It's applicable. The reasoning would be applicable to both suits. There will be two different reasonings from the court. It may be similar, but the court will provide two different reasonings for the two different suits. These are two different suits. This time, sometimes the court would consolidate it and make it one suit. But this time around, they didn't do that. They had the two cases differently and separately, and they decided that they were going to rule on it separately. So that's why you realize that the court called one, the Richard Sky case first, and called the second after it had given its decision on the Richard Sky case. So the reasoning, there will be two different reasoning, one on the Richard Sky case and one on the Dr. Mandawe case.
So the Richard Sky case was seeking the court to declare the bill null and void.
Exactly.
Because according to the plaintiffs here, it breached some constitutional provisions.
Yes,
some provisions of the 1992
the Parliament did not have the requisite quorum to pass this particular bill. And Amanda Odoe's case was basically on the financial obligation they had to put on government. So these are the two separate cases. Even though they were all seeking the same thing, they all came into court with different issues, and the court is going to deal with the different issues. But now what is going to happen is that Parliament, now that the case has been dismissed, Parliament now has the power or the free will to transmit the bill to the president for assent. And it is now the prerogative of the president, after this bill has been transmitted, to either assent to it or decide not to assent to it. When the president doesn't assent to it or decides not to assent to it, what happens is that he has two options. He has to return to Parliament and tell Parliament that these are the reasons why I have decided not to assent to it. The other one is to refer it to the Council of State. And also give the Council of State the reasons for the Council of State to have a look at it and also see what they can do and can send back to Parliament for a decision to be taken. So now we are at a point of whether Parliament is going to transmit this bill now to the president. And if that bill, if the bill is transmitted now, whether the president will assent to it. There are concerns about the assent to this particular bill. Some people and watchers have said that this bill, when assented to, has some major implications for the country, especially when you are engaging the IMF. You're getting some interventions from the IMF
the World Bank
and from the World Bank. You heard various people speak about why they believe that such people should be protected from foreign and international organizations. So now the concerns are whether when the president assents to it, are we still going to get the support we are getting from the IMF? Are we still going to get the support we are getting from foreign donors?
Exactly.
These are some of the concerns people have raised. And they are concerns which other people also believe that, look, we shouldn't care about how they are going to support us. We should first think about ourselves and see whether this thing that has been brought or this thing that the foreign people are trying to get us to accept is good for us as a people. So people have asked the president to ignore the pressure from the international powers and think about what Ghanaians want and do what Ghanaians want. So this is where we've got into. The president has to make a decision whether to sign or not to sign.
And that would